Hi folks, come on in. Dr. Lund here. Today we're going to look at behaviors from the bench from two prominent judges that have been in the news in the last few months. The first judge is Elizabeth Scherer, who was the judge for the Parkland, Florida shooting case, Nicholas Cruz. And the second judge is Judge Jennifer Darrow, who was the presiding judge for the Darrell Brooks case for the Waukesha, Wisconsin parade attack. Both of these highly educated and highly intelligent women were showcased professionally in trying these cases, and both of them had a lot of difficulty and drama to these cases. Let's start with a little history, starting with Judge Scherer. She was appointed to the bench in 2012 by a Republican Governor, Rick Scott. Her father, William R. Scherer, co-founded the Conrad and Scherer law firm and was one of George W. Bush's attorneys during the presidential election recount that happened in 2000. Judge Scherer is currently 46 years old and is a graduate of Florida State University and the University of Miami School of Law. She's been married twice. Her first marriage ended in divorce, and currently she's married to a police detective, which, interestingly, became an issue in 2016 when she declined to recuse herself from a case investigated by her husband's department. An appeals court removed her from the case, and she no longer handles cases or warrants from her husband's department, which is the Hollywood Police Department. Before Judge Scherer's appointment to the bench, she had spent a decade as a prosecutor working under Michael J. Satz, who was the lead of the prosecution team for the case of Nicholas Cruz. So now we have an issue of she is now over a previous mentor of hers. That fact has raised, I think, many an eyebrow as far as the question of bias, especially in this case and some of the decisions that she's made for the prosecution and against the defense team. She was randomly assigned the case of Nicholas Cruz, and prior to that, her cases really hadn't drawn much attention, and I don't believe any of them had been live televised. And interestingly, this was Judge Scherer's first death penalty case. Now remember, folks, this is not an analysis of the legalities. I'm not an attorney, and there are great folks on YouTube who will be able to provide those specific details. What I'm doing is I'm looking at some of the history that's public for both of these judges and looking at the behaviors that I saw during the court proceedings and maybe putting some evaluation on things I think may be going on as to why we're seeing some of the behaviors that we're seeing. These are just my opinions and my speculation. What I think are some of the really significant variables in this situation is, first of all, this is her first death penalty case. I think that's a significant issue for any judge or any attorney. There is a heavy burden of being part of a determination of whether somebody lives or dies. And in the situation with Nicholas Cruz, he already admitted guilt, and so this lengthy trial was, again, for the jury to determine if he was going to live or die. So I imagine on a legal spectrum, there are a lot of rules, statutes, boundaries, all kind of rules of law that a judge has to be aware of. And so I think that would add a significant amount of pressure to a judge who has never dealt with this before. Another issue I think is really significant is the fact that her boss, her previous boss and mentor, was the lead prosecutor in this case, who was a veteran attorney. As you watched him in court, he was well versed. I think that would put anybody in a very different situation because of the relationship that was previously formed between these two. I mean, it's always difficult to reestablish roles with a boss and a mentor, especially when you become the person in charge or the person over a previous boss. There's a dance that has to be done, and sometimes it works and many times it doesn't, to reestablish your role and how each of you are going to carry out your functions in a very different way. Mentors and bosses know your strengths and your weaknesses. Take pride that you've gone forward and moved on in a career, but we usually don't end up being in charge or being over a supervisor or a previous boss or a mentor. That's a unique situation, and I think that adds a lot of pressure as well, is you still want to have that person to be proud of you. You still are invested in performing at a high level to demonstrate your competency. Another issue that nobody can ignore is the fact that this case, the world was watching. I don't know if she's had previous court cases where everything was streamed live. I don't believe so. So now you have first death penalty case. Your previous boss and mentor is the lead attorney on a prosecuting side, and everybody is scrutinizing every single move you make. That has got to be tremendous pressure. Everything from how you look, what you say, how your hair looks. Your eye makeup seemed to be a big issue with Judge Scherer as well too. Things that could look like you are not competent in a certain area or you don't have the confidence. How you lay down the boundaries of how your court is going to be executed during this course of a trial. There are a lot of issues, again, with the world watching every single move you make. I think that's, again, a very unique and pressurized situation. And there's also an image. Everybody professionally has an image as far as how they want to be perceived. Nobody wants to look weak in their profession, but how do you reinforce your competency and your strength in your particular area, especially with a judge, that you're human, but you're fair, and you are in control of your courtroom? The first thing that I noticed about Judge Scherer when I started watching the trial was, my impression was that she had not been a judge for very long. I didn't realize that she had been a judge for 10 years. I also thought that she had difficulty and challenges in setting boundaries with the attorneys. There were times where she scolded the attorneys about when she came into court that everybody should sit down and be quiet and listen to what she was talking about, where she had let that go over a period of time and then became frustrated and angry. And that's how she then dealt with the issue instead of dealing with it quickly and upfront, so it didn't get to the point where she was frustrated and came across as a parent scolding children.
We're waiting for 40 more witnesses. Even if you didn't make your decision till this morning, to have 22 people plus all of this staff and every attorney march into court, be waiting as if it's some kind of game. I have never experienced a level of unprofessionalism in my career.
Judge, you're insulting me on the record in front of my client, and I believe that I should be able to
Okay,
defend myself.
you can do that later. You can make your record later, but you've been insulting me the entire trial. So, quite frankly, this has been long overdue.
Her comment about having this interaction with both sides feeling they've been insulted and that it's long overdue is, to me, an indication that she has not addressed things in a timely manner in order to keep the boundaries set and consistent. Let's listen to this next interaction.
Please go sit down.
Judge.
You're inappropriate and out of line.
Your children, you would definitely notice it.
You need to sit down right now. You're out of line. In fact, you're excused.
Judge, I asked you to go sidebar on this matter.
You, sidebar or not, you don't have one of your assistant public defenders say something about my children. You can go ahead and call your next witness.
I just need to say that the defense is not attempting to curtail the limits of the sentencing proceeding or the rights that the victims' families have. We are not trying to do that. But the state attorney's office knows that what is happening here is beyond what the victims' families are constitutionally protected to do. You can say whatever you want to Mr. Cruz. You can attack him and say whatever you want. But your honor knows that what is happening here is not permissible.
Ms. McNeil, stop suggesting that I know that something is impermissible and that I am allowing it to happen. You're finished. I've heard your objection. It's noted.
Obviously, anybody who watched the trial would notice that there is a significant difference between her interactions, her tone, and her demeanor with the defense team versus the prosecution team. Her interaction with the defense team is more reactive, hostile. Even her hand gestures are things you might do to a child of, sit down. It's noted. Very dismissive. I would imagine if a defense team may be doing things that are not within the boundaries and the rules of a particular court and case, there are definitely more appropriate and respectful ways to set the boundaries and address those deficiencies in procedure. However, it seemed very soon into the trial that Judge Scherer was doing sort of the same kind of snarky comments with the defense. It didn't build very slowly. It seemed to come on quite quickly, and I didn't see that with the prosecution. And of course, I have to wonder, one, is it because the prosecution was doing everything totally by the book, which is a possibility, or was it because she knew the prosecution's team, she worked under the lead prosecutor, she seemed much more respectful of speaking with them, and that, to me, very soon in the trial, gave me the opinion, yes, in fact, she did have a bias against the team. Could it be because of the crime that they were defending from, what their job was with the shooter? Could be. It's a heinous crime. However, the impartiality of judges, the fairness, that was something I saw was lacking in this case and with Judge Scherer's behaviors. What I also noticed, too, is that she tried to give the image that she was a no-nonsense judge, a kind of a Judge Judy, if you will. And that didn't seem to work. It seemed that her own outbursts were a product more of her frustration. I think maybe even covering up some competency issues. I noticed there were times during the trial that she wasn't quite sure on a particular procedure or statute or a form. And when she would look up, it appeared to me from where I sat and what I could see from the live feed is that she was asking those questions to the prosecution's table about what form needed to be done, and how many years did a particular crime warrant. And so those type of things, which maybe in isolation may not add up to much, but to me it seemed that she still saw this prosecution group as her ally, more than being impartial to both sides. I think there were times too where she became so reactive, and defensive that she wasn't hearing what the defense attorneys were saying to her, especially in the situation about apparently one of the family members had brought up something about if it were your children, and the defense was concerned about this having some kind of impact or implied threat. And when one of the defense attorneys was trying to explain this to her, and then had used the example after she said, "What about your children? I didn't hear anything about your children." And he used the example if they had said something about your children. And her knee-jerk reaction was, instead of hearing what he was saying and using that sentence as an example, she really reacted strongly, saying, "You're threatening my children," and kind of had gone on with the argument with one of the defense attorneys, I guess supervisors, about, "Well, you don't know if I have children, you don't know if I'm barren," which the word barren I found really interesting that she utilized that word. We don't use that word in the medical community. It's an old word. To me, it almost sounds biblical. So I don't know what that means, but I found that rather strange. And so again, I think sometimes with her emotional reactions, she sometimes was not hearing the points that were trying to be made because she was already getting her response in her head before she heard the entire statement being made because of the high stress, high emotion. I think as well, too, that she really, I think we saw a lot of the humanity in Judge Scherer when the families were giving their final impact statements. Some were very powerful, all were very powerful, and you could see on her face that she was feeling emotion. Looked to me at times she was near tears, which is appropriate when you're hearing people's horror stories and how their lives and their hearts are forever changed. But the one interesting thing, again, I listened to is when the families thanked her for her job and thanked her for what she did during the trial. This is again my interpretation, some of that I understood to mean because the families were so angry at the defense attorneys because they were defending the man who killed their loved ones. I think what I felt from that interaction and those statements, that every time she was defensive or hostile to the defense team, that seemed to be something that the families liked because they had so much animosity toward this team. Even on one level, I'm sure they can understand the shooter had to have representation, but again, were not in that situation, and so anybody associated with the shooter would not be, I think, in any family or victim's mind, an ally to them whatsoever. But I think she took that, again, very heartfelt, but there was just something that I thought of, you're going after these defense people because they're horrible people, because they're defending a murderer, and that's not right. And we're glad that you cut them at the knees every time they try to object or they do something, and you're taking on the cause and you're fighting for us. And again, that sort of supported my thinking of there was such a bias that was being built up. There was another example of something that struck me, and to others it may not even have appeared to be anything or a little thing, but I look at the little things. And it was during the time when a mother who was black and was talking about her daughter who had been killed, and giving the account of how the school and the principal had slighted her daughter, of putting her into an accelerated class because she had gotten great grades in a particular class, and had not even mentioned this to the mother during a parent-teacher conference, and then talked about feeling very slighted at the hospital when her family was the last family that was given news about the fact her daughter was no longer alive and had in fact been killed. During that woman's recount of these horrible things that had happened, the judge started writing something. And maybe she had done that during other family statements because the camera was not always on her. But I thought, if any time is not appropriate, as this woman is recounting the way how she felt, she and her family and her daughter had really been slighted, left out, felt less than, this is not the time to put your head down and make notes on something. Do that afterwards, after she makes her statement, but give her full attention and full eye contact, because to me, that only reinforced exactly what this woman was experiencing. And now she was sort of getting this discounted sort of attitude from the judge. Something I do not think that the judge did on purpose, but in listening to the story, it was like, oh, Lord, this is not the time to do this to this woman if you're actually listening to what she's telling you. And then I think to wrap it up, folks, on this first part of behavior from the benches is after sentencing and when the trial was over. One thing to me that was so telling is when the judge came off of the bench and hugged all the team on the prosecution. Of course, none of that interaction was done with the defense team. That, I thought, was really telling about, I think the judge was getting as much support from them as they may have thought they were getting from her. She seemed to need the hugs from the prosecution, and I thought that was so inappropriate. I don't know if that's something that's done in court cases. I've never seen it in the ones I've worked on. Hugging the family members, again, I think that's the humanity. This was a horrible case that will change the lives of everyone who heard, watched, and was involved in it. And her being sort of the pillar of justice, I think supporting the families by coming off of the bench and sort of entering the human race and hugging and touching was again, I thought that was a pretty awesome statement of her. But to do that with the prosecution, I thought really that was inappropriate. And from what I understand at the news right after the trial is that there currently is an investigation that's being launched into the attorney who gave the finger to the camera. And there have been complaints from, I think, some of the legal folks and from, I suppose, some of the oversight agencies in Florida about the demeanor and the performance of Judge Scherer. So only time will tell, but one question I had that I don't know the answer to, and maybe one of you do that are listening or have experience with this, is as a therapist, at least in my day, we couldn't do therapy with individuals unless we were going through therapy or had therapy. And usually it was an ongoing process to ensure our issues didn't come into the therapy room when we were dealing with somebody and their problems, that it wouldn't trigger my own bias about a particular subject or topic or trauma. And so that's what tried to keep our profession in alignment. And I don't know, and would probably need to research to find out if judges have somewhat of the same type of, not so much supervision, but again, a debriefing, a sort of a regular debriefing, to have somebody that's outside the case but in the profession look and listen and be able to help a particular judge look to see when they're bringing their own issues and biases and traumas and negativity or color, so to speak, into the courtroom, that will affect how they treat and how they present certain subjects and statements. To, again, we're humans taking care of humans. And so when people say it's just business, it ain't never just business. It's always personal. If you're dealing with people, it's always personal. So anyway, folks, this is just something to think about. I would love to hear your thoughts. What I'm going to do next is part 2 is do something similar, background and sort of a summary of behaviors I saw from the bench from Judge Dower, who was the judge in the Darrell Brooks case. And again, very different circumstances. However, kind of, well, Brooks doesn't have a life or death case because there is no death penalty in Wisconsin. However, another very interesting case where we will be looking at behaviors from the bench. So thank you all for listening, and if you like this, please subscribe. Thanks.